Former President Jacob Zuma's application for rescission of his 15-month contempt of court sentence hinges on the United Nations Covenant on Civil and Political Rights. The Constitutional Court has asked all parties involved in that matter if it is in fact obliged to consider the covenant and what implications it would have on Zuma's detention. So according to Article 9 of that covenant, a victim of unlawful arrest or detention is entitled to enforceable compensation. But actually, what does that even mean, and what are the implications for the Apex Court directive? Let's get some answers now with the University of Pretoria's public law expert, Professor Koos Malan, who joins us via our video link. Prof, great to see you. Thanks very much indeed for making time for us here on the AM Report.
Thank you.
We'll unpack the...
Good morning, my pleasure.
Sure. We'll unpack the implications in just a moment. Let's begin with some context if we can. Under what conditions, if any, can anyone look to international law if they feel like the law in a said country has not necessarily done well to them?
Well, under the present South African constitutional order, there is in fact ample room to consider public international law. As a matter of fact, not only to consider it, but to compulsory take it into account. There are two sections that are involved here. Firstly, Section 231 of the Constitution. That obliges us, that's now a South African court, whenever South Africa has entered into an agreement, an international agreement or a treaty as it is called, including what is at stake in this particular case, the International Covenant on Civil and Political Rights. That agreement has indeed been entered into by South Africa, by the executive back in 1994. It has been ratified by Parliament, and South African law has to comply with it. That's the one section. The other section is Section 391 of the Constitution, that also says that even such law into which South Africa has not entered into as a treaty party, even such law must be taken into account, must be considered, to use the specific words of the Constitution. In this particular case, South Africa has in fact entered as a contractual party to that agreement, to the International Covenant on Civil and Political Rights. So our law has to comply with what is stated in that covenant, specifically in this case Section 9 and Section 15 Section 14 of that covenant, which are pertinent. But strictly speaking, to my mind, there is no question that should in fact not be a problem, because South African domestic law is perfectly consonant, is perfectly complying with our international obligations in terms of that covenant. If you look at what the Constitution says in the first instance, in Section 12 and in Section 35(3) to be exact, concerning the rights of accused persons, and also if one considers the contents of the Criminal Procedure Act, which is the specific legislative instrument which is relevant here, it is quite obvious, quite clear that South African internal law, South African domestic law completely complies with the international obligations.
Now, this covenant, the UN Covenant on Civil and Political Rights, also covers the right to due processes. And this, according to many, has been the thrust, really, of the former president's legal team's argument. What typically is the starting point when an international court thinks through things? Are they looking to see if South African judges have followed the law, or are they trying to ascertain whether the law itself is problematic?
Well, look, in the first instance, that's not the duty of an international tribunal, such as the International Committee of Human Rights, which is responsible under the covenant to administer the covenant. It is in the first instance the duty of the South African legislature and then also of the South African courts to make sure that that domestic South African law is in compliance with international law. And I think as far as that is concerned, there's in fact no problem. When it comes to a specific case, such as this case concerning the former president, the court must in the first place see to it that South African domestic law is properly complied, and is also complied in such a way that it is consonant with international law. Now, as I've said, if you properly apply South African law, which is in conformity with the International Covenant on Civil and Political Rights, there would in fact be no problem arising precisely because of that consonance between our domestic law and international law. So so strictly speaking, it means that there's actually no specific need to take into account over and above South African law, international law, precisely because South African domestic law is a perfect reflection. There's no question about that of the international law position.
Right. So in a context where, just to make sure that I've understood you correctly here, Prof, in a context where we know our law is compliant with international law, what is, do you reckon, the point of contention here? Is the question being asked by an international, is the question being asked to an international court whether or not our judges have actually been, call it, accurate in the implementation of our law?
Yeah. Well, the only point of contention that might arise in this particular case is that it might be argued by one of the parties, say on behalf of Mr. Zuma, that the way in which the Constitutional Court has gone about up to this stage is not in compliance with international law. And obviously, on behalf of the Zondo Commission, which is the opposing party in this case, a counter-argument would be proffered, saying, no, we have in fact complied with international law. It's an issue that really does not arise. Now, I think if I can perhaps foretell what the Constitutional Court might say in this regard, I think the Constitutional Court knows it. The Constitutional Court knows that it has not acted contrary to international law. But what it should do is actually to make sure to act in a very cautious way, and actually to invite the parties to make possible recommendations, to make possible arguments, just to make sure that it has in fact, exclude that 1% possibility that it does not in fact comply with international law. And that, I think, is the reason for this directive that has now been issued by the Constitutional Court, inviting the parties to address it, or then at least to make further recommendations in writing, so as to enable the court to make sure whether any possibility of not having acted in compliance with international law is expelled.
Certain clauses in Article 9 of this treaty for me are quite interesting. If you'll just indulge my reading out just one aspect of that,
sure.
And you'll tell me whether you think that's where the rubber hits the road. So part of what Article 9 actually says is, anyone arrested or detained on a criminal charge shall be brought promptly before a judge or the officer authorized by law to exercise judicial power, and shall be entitled to trial within a reasonable time, or alternatively to release. A lot of what the former president's team has been saying is that it's unfair that he's essentially been sent to jail without being given a trial. Could they cite this as a part of their reasoning?
No, I think the president's argument, or the argument proffered on behalf of the president, is patently wrong. The fact of the matter is that the president was brought before court, not so much physically, but at least he was given the opportunity to address the court fully regarding the possibility of his incarceration following a conviction for contempt of court. The president, with all due respect, cannot complain at this late stage, because he has been afforded all the opportunities. As a matter of fact, the Constitutional Court has been criticized for actually giving him more than what was required. The only reason why the president can now possibly complain is because of a fault on his own part, because he has opted not to participate in the Constitutional Court's hearing. What has been happening is there is an incarceration of Mr. Zuma at this stage, but it is not an incarceration before a trial, it's an incarceration after a trial, because there was in fact a trial, even in spite of the fact that he opted not to participate in that, and the incarceration has followed after the trial, not before the trial.
If I can come in there quickly, Prof, does it not matter that the Constitutional Court gave out a sentence, this jail sentence, but then didn't give the former president an opportunity to respond to that?
Look, the sentence works like this. If the court considers, like in this case, that there's a possibility of a conviction for contempt of court, then the accused, or the defendant then in this case, is given the opportunity to address the court on the merits of the case. In other words, whether or not he's guilty. Over and above that, there's also arguments that can be advanced regarding the question of a sentence. Now, the president was given the opportunity to address the court on both and he actually failed to do so. What has been happening in the meantime, okay, let me just finish that argument. So he has failed to do so. Now, a court can be left with no other option than simply to proceed, because otherwise it is actually held ransom by a non-cooperative party. So obviously that cannot be allowed to happen. That would fly in the face of the basic principles of the rule of law, and that would mean that any party who fails to contribute with the court, even after he has been invited to do so, can actually make it impossible for the court to function. That obviously cannot be allowed.
Koos Malan, great to speak to you, sir. Thanks very much indeed for your take on this issue. Koos Malan is a professor of public law at the University of Pretoria. Once again, Prof, appreciate your time on the AM Report.